My learned friend, my file has been misplaced. So I've requested him to give me a copy and let it be taken on Friday, this Friday.
As it is, this is for only one day.
Beg your pardon?
This code is for only one day.
Oh.
Benches for only one day.
I see. Then I'm unlucky, my lord.
On Friday?
Friday, if your lordship sits.
It will be shifted to another bench. So Friday hearing matter. Should I
Thursday.
leave the date open? Thursday?
Thursday, your lordship can take.
Okay.
And in regard to item 10.
With consent of others,
Next week. Lord, in regard to item 10, it may be after 1 week. This is a joint prayer by both.
Oh, as agreed by both the sides.
This
is item 10.
10.
Earlier one was item 3.
8.
8, okay.
Obliged.
All right.
May I please, Lordship? My lord,
Yes,
I beg
yes.
to mention item number 12, my lord. With the consent of the other side, my lord, this matter may be taken up in the month of December, my lord. I've already
Okay.
taken consent, my lord.
All right. Learned counsel, Mr.
T. Sheikh, my lord.
T. Sheikh, with the consent of the other side, has
Right.
prayed for adjournment, list the matter after 4 weeks.
My lord. Highly obliged, my lord.
With consent of the other parties, I beg to mention item 11, my lord.
Hmm.
Here, my lord, a brief is just missing, my lord. We have already informed us opposite side, they have no objection. So after 2 weeks, maybe.
Learned counsel, Mr. A.K.
MJ Borua,
Learned counsel, Mr. M.J. Borua has submitted that the brief is missing.
yes.
The full stop. Learned counsel, Mr.
V. Basfor, Vinod Basfor on behalf of Endega.
B. Basu.
V. Basfor, BSFR.
Basfor.
B. Basfor on behalf of Learned counsel, Mr. Endeka is present for the respondents. List the matter after 2 weeks.
2 weeks, my lord. In May, December first week, it may be.
That will be 3 weeks.
3 weeks.
List the matter after 3 weeks.
Obliged,
Deeply.
Just leave your lordship. Lordship, victim item number 14, daily list lordship. With consent of the other side lordship, can it be matter be fixed in 11 of November lordship? My senior is out of.
Can be. Learned counsel, Mr.
N. Borua.
N. Borua on behalf of Learned counsel, Mrs. M.D. Chaudhary, with the consent of the other side, has prayed for adjournment. List the matter. When do you want?
11th of November.
List the matter on 11 November.
Most of this. May I plead? So I have mention for listing on IA lordship. Any date lordship?
You have to rush to code number 11. Code number 8, okay? Code number 8, not 11.
Item 1, Lordship. My lordship, this judgment squarely covered my lordship own judgment on bail application 468/2025. I have been detained for the bar for 11 months. And search sheet has been filed by the questary. It has been reflected in the page 35. Now, in this case, your lordship, in arrest memo, no arrest memo, no ground of arrest, nothing.
We will need the LCR, whatever it is. We'll need the call for the scan copies of the trial court record and the scan copies of the entire CD. This the matter on after how many days?
14 year lordship, fix of 14 year lordship. Search has to be framed.
On 14 November.
And deeply first. Item 2.
My pleasure, Lordship. Lordship, the updated CD was called for.
Do you have the CD up to date?
Received CD, my lord, but yes, my lord, updated CD received, my lord. So, my lord, this matter, my lord, maybe my lord, after some time, my lord.
After some time?
After some time.
Item 17.
এইটো আগতো এবাৰ হেৰি হৈছে নেকি আহা নাই নেকি
My lord. In our last question also, it was, my lord, adjournment.
for adjournment.
That was prayed for adjournment.
Petitioner is not represented. List the matter after 2 weeks.
My
Item number 3 for orders.
My lord, what happened in this matter is that, my lord,
The office note that was prepared, my lord,
Hmm.
was prepared wrongly, my lord.
Hmm.
And it was in the office note, it was mentioned that service upon respondent number 1, 2
Hmm.
and 4 to 7
Hmm.
was not done.
Hmm.
However, my lord, we had already taken Dusty and already filed the affidavits, my lord. So service is completed, my lord. So it will go for admission, my lord.
Okay. Office note is wrongly
Yes, wrong prepared, my lord.
entered.
Yes.
Office note dated
19/8/2025.
Learned Counsel Mr. S. Das is present for the petitioner. It is submitted that the office date note dated 19/8/2025 is wrongly entered as you have filed an
Dusty.
affidavit
Dusty, yes, Dusty affidavit is there, man. We have filed.
as an affidavit relating to
Dusty service upon respondent number
service of notice through Dusty service on respondent number
1,
1, 2,
2 and 4 to 7.
and 1, 2, and 4 to 7 has been filed by the petitioners.
It should be there in the last
Yes,
one.
yes. An affidavit in support of service of notice upon the respondent number 1 has been filed, and it is submitted that the
Respondent number 1 has received summons on behalf of the other respondents. All the notices are there.
the deponent Dhaneshwar Roy has personally served a notice to respondent number 1 served a copy of the notice and memo of appeal to respondent number 1. Which is marked as who is respondent number 1?
One is my lord Bhelubala Rai. Bhelubala Rai.
Annexure 16. Full stop. Notice has been received by respondent number 1, Bhelubala Roy, comma. Notices have been received by respondent number 1, Srimati Bhelubala Roy. Full stop. He has also marked the affixed a thumb impression on Annexure 16. On the notice marked as Annexure 16. Only one, Bhelubala Roy.
No, all the notices are there, madam.
Oh, she has received notice for all.
All.
Oh.
Separate notices are there.
The Annexure 16 also depicts that Bhelubala Roy has received notice for other respondents. I responded number 2,
Rambha Baboti.
Rambha Baboti Roy, within bracket Pathak, Bijit Kumar Roy, RUID, comma respondent number 5, Josna Roy Chaudhary, comma respondent number 6, and Nobonita Chaudhary, respondent number 7. Thus, notices have been served to the respondent number 1, 2, 5, 6, and 7. What about 4?
Form probably my lord already served. Yeah,
I'll check.
order will be there, my lord. Initial order.
I'll read. No, of course.
Four, I'll have to verify, my lord. Probably whether a notice upon 4 has been served or not, that you have to verify.
You issue notice?
My lord,
There's nothing about 4.
4. Then I'll take Dusty upon 4 also, my lord.
Petitioner may take steps to issue notice to respondent number 4, returnable within 4 weeks. Learned Counsel Miss
S. Pal appearing on
S.
behalf of
Pal, on
B.J.
behalf of,
Mukherjee. B.J. Mukherjee.
is present on behalf of Learned Counsel Mr. B.J. Mukherjee for the representing the respondent. List accordingly.
I'll do this.
Lordship, item number 17, my lord, I miss.
Dusty mode is also allowed, will लिख दिया. Item number? Okay.
I'm sorry, Lordship.
Okay, it's all right.
17, Lordship. Lordship, on last occasion, Lordship, there is a Supreme Court judgment which was directed me to verify. I think, my lord, gone through that judgment, my lord. But the matter is still fixed for, in that case, Lordship, amicus who is affected and fixed for on 12/11/2025. And one more
This is the
judgment.
first time or this is your, I have rejected earlier. bail
No, my lord,
petition?
earlier Lordship is closed due to the Sachit file. Lordship.
Okay, okay.
My lord. Only problem is the Lordship, my lord, the case is triable by lord session, my lord, Honorable Court of Lordship. The case is fixed for the my lord, learned exigent.
You see,
And the very first
you
day,
see, you withdraw this.
Lordship.
This is a good advice from me. You withdraw this, you pray before the sessions, make a prayer before the sessions. If that is rejected, then you approach this court. Then we will abide by the guidelines of the Supreme Court.
No, my lord, guideline is not.
We cannot
lord,
circumvent the guidelines of the Supreme Court.
My lord, the guideline is not till now not framed. Lordship. Is the husband, Lordship.
Not framed, but there are already existing guidelines.
Lordship, there is a in the other husband there is a just observation to that the High Court
Not to encourage.
not to encourage.
Not only one judgment, there are several judgments. So why should we not comply with the direction of the Supreme Court?
Yes. And my lord, the latest case is my lord fix on my lord 12/11/2025 for the amicus curiae report. Lordship. This is the husband, Lordship.
I couldn't understand. I didn't follow you.
Lordship. The latest, my lord.
So we will fix it on 12 then, after 12 then. Or else you withdraw or we'll fix it after 12. Or else I'll give a direction that you approach the session judge.
Lordship,
and
Lordship, let me be.
I'll give a direction.
Lordship, Lordship. In terms of Lordship may observe that, my lord, that case is pending B for the execution, Lordship, learned execution. For the
Learned counsel, see, this will go against you. Why do you want me to make this observation? This will go against you. Why are you not taking my proper advice? You withdraw this. Or else I can fix another date. You ponder over it.
Lordship may fix.
If I direct you to appear before the jurisdictional court, and then the court will decide, this will definitely go against you.
Yes, yes.
Why are you closing all the doors for yourself?
Then, my lord, direct to the learned session court, Lordship.
No, why should I direct to a sessions court? You'll be directed to the jurisdictional court first.
Mhm.
Why I will direct the sessions court? This is not a judgment,
Lordship.
criminal division petition or anything of that sort.
Lordship.
দুসপ্তাহ পিছত তোমাৰ ডেট দিয়া আছে এনে দুসপ্তাহ পিছত দিছিল
You ponder over it. Come at 12.
Lordship. Police.
Ponder over it. Okay? Learned, it presents to Lydia.
Lordship may fix a date on the Friday. On Friday.
Cannot follow you. What are you saying? Cannot follow you. Friday?
Friday.
Okay.
I'll think about it.
Learned counsel and release this matter on Friday, Lydia.
Sorry. Diplomacy.
Item 3.
My lord, with regard to item number 3, my lord, I have found the notice upon response number 4. It is there, madam. I flagged mark it. Deben.
Oh. Will you change code? Yes, this is response number 4, no?
4.
Then notices have been served to all.
Yes, yes.
Oh, look at it. তলৰ paragraph যোনটো আছিলে response number 4 এইটো কাটি দিয়া। The annexure 16 also depicts that notices have been served to respondent number 4, Deben Roy. এইটো মিলাই মেলি দিবা হা, sentence খিনি তোমাৰ মতে মিলাই মেলি দিবা। Deben Roy, তাৰপিছত এই লেডি গৰাকী আছিলে যে প্ৰেজেন্সটো, we have the LCR.
Answer is there.
As the scan copies of the trial court is before scan copies है केले दिले था ना scan copies हाँ original আছে না as the scan copies of the trial court record is before us, list this matter for admission.
Admission, madam.
At admission time, if you want the original copy, you can ask for a direction. I do not know why the scan copies were sent. Scan copies please let me give. नहीं scan copies में लिखा नहीं scan और scan copy भी लिखा से
Item 4.
And will it be listed in the month of December, madam? Second week or third week, madam, for admission?
it will come
Second week
December.
of December.
She's
No
not
fixed
there,
date.
no? She's not there.
I'll inform, madam. Second or third week of December,
3 weeks.
madam.
After 3 weeks.
Made page alert. This IS Civil 1500 Old Lordship for implement of respondent numbers.
I need some sort accommodation for filing the objection, madam. 1 week,
Actually,
madam.
in this
Date may be
matter, I
fixed.
think objection is not required as because they were already party before the learned trial court. By mistake, I left those persons while preparing the regular second appeal, Lordship. It has been clearly mentioned in my, they are already party, Lordship.
1 week
They-
time, madam.
Maybe they impleted and thereafter they can file their objection.
After it is they are implemented, madam, it will go for hearing, madam. So, madam, at least one opportunity, madam, 1 week.
Objection.
Date may be
Lordship,
fixed,
They
madam.
are already.
I also don't understand why he wants to file an objection.
Date may be
Okay.
fixed, madam.
That
Next
is,
week,
I
any date, madam.
categorically stated in paragraph 3 that the applicant begs to state that the name of defendant numbers 5 to 8 They are already party before the learned trial court. It is my mistake. I have not completed them as respondent in my memo of
Because
appeal.
my lord,
Lordship.
limitation thing all will be have to be seen, my lord.
Appeal already
Because
admitted, Lordship.
because my lord, against me, they did not file their
Only 1 week then.
yes 1 week.
Lordship, last chance, Lordship, already they have taken time on 29/8 also, Lordship.
Learned counsel Miss R. Chaudhary is present for the applicant stroke appellant. Learned counsel Mr. S. Das is present and has submitted for time to file objection against the interlocutory application. Full stop. The learned counsel for the applicant has raised objection stating that there appears to be no justified ground to file an objection as they were already parties in the original suit.
Yes, Lordship.
Original title
Suit
suit.
title
Full
appeal,
stop.
they are parties.
Considering the submissions of at the bar, a last opportunity is afforded to the respondents to file objection. This the matter after 1 week.
Lordship, a date may be given kindly
Date
on 10th of November, Lordship, or 12th of November, Lordship.
12th.
Obliged.
May it be on 13th of November, my
No,
lord.
obliged.
Highly obliged.
Item number 5.
May I please, my lord? My lord, there is a IA case which I being the respondent in the second appeal, I have filed IA case number 3318, which I have filed for expeditious hearing of the second appeal, because second appeal has been pending since 2012 for hearing. I am the sole respondent.
Okay, we'll fix it on when?
Fix it on either on it may be on 25th of November. That is a Tuesday. Hearing day.
Yes. Actually, I have nothing to do with because this is for only 1 day. I'm
Yes,
sitting.
I understand that.
But you see, if the docket is full, if the cause list is full on that day, they may not take up. So it will be better to fix on a later date, I think.
Later that in the first week of December.
First week of December will be better.
First week of.
I'll fix a date.
Yes, that will be very convenient, my lord.
Third learned counsel, Mr.
S. Borua.
S. Borua, who has filed this application with prayer for who has filed this application on behalf of the appellant.
Respondent
On behalf of the respondent
for expeditious hearing of the appeal.
for expeditious hearing of RSA 61 of 2012, preferably within the month of November. Full stop. It is admitted that this second appeal has been pending since 2012 and expeditious hearing is necessary. Full stop. Considering the length of pendency, comma, this application is allowed. This the RSA 61 of 2012 for hearing positively on 2nd December. Will be a holiday or not?
2nd December may be a holiday.
Then 4th December,
4th
Thursday is a hearing day.
Thursday is
4th December,
4th December.
positively.
Positive.
Oh,
I disposed. Obliged.
in terms of the above observation, I stands disposed of.
Item 16 of the supplement for
May it please your lordship. Your lordship, this is an appeal under section 173 of the Motor Vehicle Act, your lordship, challenging liability as well as quantum, your lordship. As regards liability, your lordship, our contention is that the tribunal has settled entire liability on us, your lordship. There were 2 vehicles involved, and our contention is that there ought to be contributory negligence of the deceased, your lordship. And as regards quantum, your lordship, there
74.
ought to have been some deduction towards income tax, your lordship. So your lordship may at least please appeal and we will deposit 50%, your lordship, at this stage.
With the liberty to withdraw the same.
Lordship.
Who's over? I,
Yes.
I is for stay,
there are
your
two
lordship.
IS, huh?
I for stay, my
Stay,
lord.
your lordship. One is
Okay.
for caveat. Other one is
One is caveat, no?
Lordship will admit the petition and call for the record.
Hmm,
And in the meantime, in the IA,
hmm.
they were direction may be given to deposit the 50% with the liberty to the respondent. He will do the same.
I had to likha.
This MC appeal is also there, your
Yeah.
lordship. That has to be admitted, your lordship.
Can I
Because-
pass to an order together? Club I and appeal together?
Maybe.
Can, no?
That's
We can do.
Last
Lord-
year,
Yeah, I और appeal दुटा लिखी दिया.
Your lordship will dispose the IA first.
It will be disposed of
Yes.
together or you want separate orders?
No, same order.
Learned Counsel Miss P. Goswami is
P.
present.
Bodhapur,
P.
Bodhapur,
Bodhakur is present for the. Yeah.
appellant, your lordship.
P. Bodhakur is present for the appellant. Stroke applicant. Oh no, applicant will be you. No, no, again.
In the main appeal, we are the appellant, your lordship.
Appeal to agar लिखी दिया. P. Learned Counsel Miss P.
Before
Bodhakur
that,
is
your
present.
lordship will have to discharge the caveat. The caveat
Will
was.
discharge.
Okay.
Caveat is discharged लिखी दी.
हाँ.
As the caveat is present, caveat is discharged. Itu report लिखी. Caveat कौन लिखी दी बोलते. Learned Counsel Miss P. Bodhakur is itu MAC to लिखी दी बा. MAC appeal to. For the appellant. And has submitted that the tribunal has erroneously passed an order holding both the insurance companies liable
Holding only
or
Our company
holding
the
only
appellant
the
liable.
holding only the appellant liable instead of holding both the holding both the offending vehicles as liable for the accident as the accident was a result of contributory negligence. Full stop. The order in MSC case number 2108 by 2018 is hereby challenged by the appellants. Dated लिखी दी बादे. MSC 2108 of 2018 dated 12/10/2018 is hereby challenged by the appellants. Full stop. Learned Counsel, Mr.
K. Bhattacharya. Hearing for respondent number 1, 2, 3.
For
1, 2,
respondent
3.
number 1, 2, 3. Who are the claimants?
Claimants.
Admit लिखी दिया. There are other respondents also.
Yes, your lordship. As regards respondent number 4 and 5, we shall take steps through usual process, your lordship.
Issue notice to the respondent number 4 and 5.
5 and 6, your lordship.
4, 5 and 6 to usual process returnable within 4 weeks.
Lordship.
Call for the trial court records. List accordingly. You know, I to लिखी दी बा.
I 3149, your lordship. That is for stays.
Learned Counsel Miss P. Bodhakur is present for the applicants and has prayed to stay the operation of the order
Into judgment and award dated 4/2/2025.
dated
4/2/25.
Lordship.
12/10 लिखी लूँ मैं 12/10 no 4/2 है अगर जो 12/10 लिखी ला 4/2
4
4/2/2025 in connection with MSC case number 210 of 2018. Learned Counsel Mr. K. Bhattacharya is present for the respondents.
No, 1 and 2.
To stop the after considering the submissions at the bar, the operation of the impugned judgment and order is stayed until further orders, subject to the condition that the applicant deposits 50% of the compensation amount before the registry.
Lordship.
Before the registry of this court within 2 weeks.
Within 4 weeks,
4
your
weeks
lordship.
from today. And full stop video. The claimants are allowed to withdraw the
See.
Same.
By filing the application before the registry.
It's okay. Same from the registry of the school.
I may be disposed of, Your
In
Lordship.
terms of the above observation, I
I-
has disposed of.
Objective.
Oblige, your lord.
Here, my lord, is a third bail application, my lord, pre-arrest bail application, my lord. My lord, yet not, my lord, that is the, my lord, the victim, my lord. He was not found, my lord, till date. My lord, now, my lord, allegation is, my lord, against the, my lord, petitioner along with other accused, my lord. My lord, last, my lord, the rejection order is, my lord, 23/4/2025, my lord. 23/4/2025, my lord. And before that, my lord, 3/10/2024, the first one, my lord. So, my lord, at that point of time, my lord, that is two numbers of in the first bail petition, my lord. Petition, my lord, appeared, my lord, where my lord was pleased to grant bail to petitioner number 2, Hasina Begum, my lord. My lord, that is who is the wife of the, my lord, that is the present petitioner, my lord. Now, my lord, allegation is, my lord, here, my lord, serious, and because, my lord, there is the victim is also not found, my lord, till date, my lord. There's some entry, my lord, police, during the course of investigation, my lord, because already, my lord, has gone through that, my lord. That is, my lord, updated CD, my lord. The one note is there, my lord. Other than that, relevant parts are there. And
Can be granted, I think.
my lord, otherwise,
Petitioner has no history of traveling to Delhi.
that part is not there, but because of that, my
Murder
lord,
case, no? Murder case.
but he is not yet
No.
found.
Hmm?
The person is not found.
Body is not yet found.
He is not found, my lord. Only the thing is that my lord, allegation is that, my lord, that is with petitioner's wife. Some my lord, allegations are there to the person.
That they had called her.
My lord. And my lord, one, my lord, independent witness said, my lord, that is also, my lord, I have flag mark, my lord, where my lord categorically stated that, my lord, before, my lord, leaving for Delhi, he told that that is the wife of her telephone has informed that he'll kill him. That is the allegation, my lord,
I'll check.
my lord. Only maybe horizontally, I like my lord, give
But
some
the
more-
phone number found there is that doesn't belong to me, my lord.
Phone number doesn't belong to you.
No.
Everything, my lord, that will come, my lord. There's one another person who has given, my lord. All are in the, my lord.
My
Like,
lord,
so, my lord,
allegations are made on mere suspicion.
his statements also, my lord, earlier recorded, my lord.
Mhm.
His, my lord, this present petitioners, along with, my lord, wife, my lord. My lord, flag mark as a note, my lord. After, my lord, from their both statement, police then become more suspicious. Because it's not, there is no, my lord, similarity between the statement of the petitioner and petitioner's wife, my lord.
এইটো NAC অকমান দেৰি কাৰণে I think can be given. Unit?
Dear Bangshari.
Hmm?
Dear Bangshari.
Okay. Her learned counsel Dr. Miss
Bangshari.
Dr. Bongchiari for the petitioner Roham Ali, who has filed this application under section 482 of the BNWS 2023 with prayer for PLS bail, as the petitioner is apprehending arrest in connection with so and so PS case under so and so section. The allegation against the petitioner is that he, in cohorts with his wife, called the victim Mr. Ali and over phone and killed the victim and disposed of his body. Out of suspicion, an FIR was lodged by the victim's father, who stated that the victim, Mr. Ali, was employed in Delhi as laborer, and thereafter he has been missing while he was returning home by train from Delhi on 21/2/2023. Full stop. A frantic search was made by the family members and the family members have unearthed that the victim was in contact with the phone number 8472019299. Full stop. It is submitted on behalf of the petitioner that this number does not belong to the petitioner. Full stop. It is further submitted that the petitioner has no no record of visiting Delhi. He never visited Delhi. On the contrary, the learned additional PP, Mr. K. Butcher, has raised a serious objection stating that there are incriminating materials in the case diary and strong suspicion against the petitioner. Full stop. The petitioner and the victim used to work together, and on a relationship between the petitioner and the victim's wife, strong suspicion arises that petitioner's wife and the victim, petitioner's wife and the victim, a strong suspicion arises that they petitioner may have eliminated the victim, full stop. The body, even after thorough investigation, the body could not be recovered, nor the whereabouts of the victim is known. Full stop. I have also scrutinized the case diary. Investigation has progressed substantially. Full stop. Indeed, the victim is indeed the petitioner is a suspect, but it appears that at this juncture, bail may be granted to the petitioner. Full stop. The petitioner is a local resident and he is not a flight risk. Full stop. The petitioner has also pledged to cooperate with the remaining part of the investigation. Full stop. Considering all aspects, petition is allowed. In the event of his arrest, the petitioner shall be enlarged on bail of rupees 50,000 to the satisfaction of the arresting authority under the condition that the petitioner shall not leave the jurisdiction of the court without prior permission. Number 2, the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 3, the petitioner shall not exercise threats to the witnesses or try to tamper with the evidence. On breach of any of the bail conditions, bail order shall automatically stand cancelled. Send back the CD.
Deeply obliged.
Item 6 for jail.
No, please.
Mm.
It's a judgment of reversal, Lordship.
Hmm?
Judgment of reversal. The suit was dismissed and
What about the other side?
the site name has been shown in the cause list, Lordship. Other side it's not there.
How long will you take?
It will not take much time, Lordship, because this is only two substantial question of laws formulated. Only thing is that with regard to the Assam Non-Agriculture Urban Tenancy Act, notice is required, no notice was issued. And the other part is that the sale deed was exhibited by the present appearance.
See, you first. Number 1, we do not know where the other side is. Number 2, we do not know how long will he take. And number 3, I am sitting for only 1 day.
Okay, Lordship. And Lordship may I fix any date in the next week, Lordship, if it is possible.
Next week. Long pending
Or-
case.
Yes, Lordship, it's
The other benches.
old matter, Lordship.
Huh?
It's an old matter, Lordship, on the last 2-3 occasions which has been listed, Lordship. If it is possible any day as
It
per
was
the
listed-
convenience, as per the convenience of this honorable court.
No. I am not inconvenienced. Okay, we'll fix it for on the next week.
Next week, Lordship. Can a date be fixed, Lordship?
Learned Counsel, Mr. P.S. Chaudhary, no?
SP Chaudhary.
SP Chaudhary is present for the petitioner.
Appellant.
Appellant. Most of the respondent is not represented today. List this matter on for hearing positively without fail, as this is a long pending case. Full stop.
11 November.
On
Obliged,
absence of any of the parties, necessary orders may follow.
Obliged, Lordship.
Item number 7.
Hey, baby, Lordship, kindly case may be adjourned to the day, my lord. Actually, my senior could not be present here. Can it be fixed 10th of December?
Can be. When?
10th of
10th of
December.
December. Can 11th,
11.
not on 10th, 11th.
11.
Learned Counsel, Mr.
Is Gogoi.
S. Gogoi, on behalf of Learned Counsel, Mr. S. Das,
Yes, that's.
has prayed for adjournment. Learned Counsel, Mr. K.K. Bhatto is present for respondent number 2. List this matter on 11/10, 11/12.
Highly obliged.
Item number 9.
My lord, I am for the respondent. And the advocate of the appellant is not present. My lord, if your lordship is see the last order, 17/9/2025.
Hmm?
17 order that is 17/9/2025.
Can dismiss it, but again,
Let there be the restoration petition, my lord. Let it be dismissed. He may not find. He may find.
I do not know about High Court rules and orders, but exactly I do not know the time about High Court rules and orders.
In that
But in
case,
lower court civil rules and orders, we have to wait till 11:30 to dismiss.
no, that is a different aspect altogether.
About High Court, I do not.
Yeah,
I have.
High Court, it is not applicable, my lord. And even
So
though, my
even
lord,
at 10:30 also we can dismiss it.
yes. But even though, my lord, your lordship may fix it on 11th. On 11th.
Or 11, last
of the-
opportunity.
as the last
One
opportunity.
final last opportunity.
Yes.
Because the appellants are not represented even today. Most of the appellants were not present on 17/9/2025. Most of the last opportunity was accorded to the appellants, but the appellants have failed to appear today. The respondents are represented by learned counsel, Mr. This will item number
9. OP Bhatti.
P. Bhatti. Full stop. A final last opportunity is accorded to the appellants on failure of appellants to appear on the next date. This necessary orders may follow. List on 11 November.
Much of it.
Positively for hearing without fail.
Much of.
Mm.
This is an appeal by the insurance company
Mm.
against the judgment and awarded at 16/12/2016 passed by the learned member of MST Porpeta in MSC case number 3.
You're the insurer?
I am for the insurance company.
What about the other side?
Well, there, perhaps we went to call the senior member. Basically, we have taken 4 grounds, my lord.
Mm.
First one is that the multiplier was not correctly considered. Secondly, my lord, that future prospect. Thirdly, that interest on the future prospect, that is not admissible. And one more grounds were there, my lord, there is the driving license was not genuine. That has been taken care of by the learned tribunal itself, my lord. It is a case of pay and recovery. It will be recovered from the owner.
You're for the owner? Who is for the owner?
No, I'm from the owner is not appearing. Owner is not appearing.
Pay and recover from the
Pay and
owner.
recover.
What about the claimant? They have.
the claim.
So they have, I think, no objection. Whoever pays,
Yes, yes.
owner pays, they'll get
Yes.
it. Insurer
Yes.
pays, they'll get it.
Okay.
You have any objection?
No. They are,
Then owner doesn't.
no, I claim from the insurance man.
Yeah.
That is the question.
You claim from the insurance
Insurance.
There is a direction of
Because-
the tribunal to pay and recover from the
owner.
owner.
So I will hear on that point alone.
No,
Then-
that observation is already there.
Hmm.
It will be recovered from the owner.
Owner.
That will be recovered from the owner by the insurance,
Yes, ma'am.
not the.
Not by the
not
claimant,
claim.
by the insurance
But
company.
his owner is claiming from the insurer.
No,
Oh,
claimant is,
you're for the owner, no?
no, claimant,
You're for the claimant.
Claim.
You want it from the
from
insurer,
insurance.
not from the
not
owner.
from the-
So you place your argument there
Yes, yes.
on merits.
Merits.
Hmm.
Basically, my lord, at this, these 2 points surveyed, my lord. First one is the multiplier.
Hmm.
In my respectful submission, that multiplier was not correctly taken, my lord. That the admitted position is that the deceased, my lord, at the time of his death, he was more than 55 years, my lord. The ground number 2 I have taken, my lord. For that, the learned tribunal has failed to appreciate the actual multiplier to be adopted in this case. As per the SSLC admit card, Exhibit 6, the service book, Exhibit 8 of the victim, he was born on 1/4/1958. The accident took place on 28/7/2013, on which that he succumbed to his injuries. As such, on the date of his demise, the victim was 55 years, 3 months, 27 years old. The second schedule of the Motor Vehicle Act, that is not there at present, my lord. The contains schedule for compensation for third-party fatal accident injury cases where the multiplier has been fixed for 8 for the age group of victim of 55 years, but not exceeding 60 years. The apex court in Sarala Burma, that is, my lord, the present.
That Trilok Chand's case.
Yes.
Sarla Verma from Trilok Chand.
My lord. The apex.
You see, how does it exonerate you? If the multiplier is wrongly calculated, I'll calculate it on a lower multiplier.
My lord.
Then how does it exonerate the insurer?
No, that is not.
You see,
basically this
I will decrease the amount, but again, the order will remain pay and recovery.
No, I'm not praying for exoneration. The basic question is that the amount.
Amount has to be
Yes.
decreased. Otherwise, you will pay.
Otherwise, we will pay.
Okay,
Because
then the owner does not have to pay.
Yes, madam, because there is a direction to pay and recover. We'll recover from
Okay.
the owner, madam. Now, in terms of the Sarla Burma case, the
So
report is.
that is what I'm saying.
Yes, madam.
See, he doesn't want it from the owner, he wants it from you.
Yes,
So
ma'am.
the argument will be limited only to that. Why you are not to pay?
I'm not.
Why you will recover from the owner? Why should I not recover it from the owner?
No, my lord, at that point, apart from that point, we are on the quantum of the amount, my lord.
It's okay. Quantum, it will be
Quantum,
decided,
it will
doesn't
be-
it?
Yes, and that second part, the driving license was not genuine. The owner and driver jointly filed a written statement saying that the driving license was genuine, knowingly that the driving license was not genuine. The official from the DTO office, he was adduced as a witness. He stated that there is no such driving license issued to the driver of the vehicle.
Which one? Witness number?
Yes, madam. Page 50 of the LCR, my lord, deposition of DW2, my lord.
They have not issued the driving license.
And that evidence remains, my lord. The deposition of DW2 Sri Vivekananda Devagoswami, who was working as junior assistant in the office of the DTO Nalbari, submitted the relevant register. He exhibited Exhibit 1, A1 is the MVI report issued by the DTO office Nalbari. He stated that as per register of driving license, the number mentioned as 363/NB/04 is not there in the register of 2004. According to the said witness, no such driving license was issued by number so-and-so in the year 2004. He knows about the issue of the report by MVI. That is the deposition by the DW2, my lord.
Okay. Yes, if the driving license is not genuine, then the owner only will have to pay.
My lord.
And anything else?
My lord, third point is that lordship.
By the way, there are judgments. Even if the driving license is not genuine,
My lord.
the owner does not have to pay. There are judgments.
My lord,
The
but,
insurance
he has to state that he genuinely allowed the driver to drive the vehicle, bona fide believe that he has a genuine driving license. But in this case, the driver and owner jointly filed the written statement showing, writing that he has a valid driving license, knowingly, my lord. In fact, had it been a case,
Insurance is only sticking to the quantum.
my lord. The third point is that, my lord, that interest on the future prospect. There is a judgment of this apex court and in our high court, but in the future prospect, my lord, interest cannot be.
Which judgment?
Judgment, my lord, I am relying upon the judgment of this honorable court, my lord. Editor.
So interest on future prospect cannot be imposed.
Paragraph 21. In the present case, my lord, interest was future prospect was imposed from the date of filing of the claim petition. May I read the paragraph 21?
Yes.
Another ground of challenge in the impugned judgment in that the learned tribunal has awarded interest on future prospect, which could not be done. In the case of Khushbu Sirenia, Elias Kanta Sirenia versus Kamal Kumar Sirenia, reported in 2018 Supreme Court GU 966, and in the case of Dasima Begum, this court has stated that no interest on future prospect should be given. Though no reason have been enunciated in the above judgment, the reason for the same seems to be due to the fact that future prospect is relatable to an income to be received in the future. As such, there could not be any loss to the claimants for the payment of future prospect at the time of decease made with the accident. The reason for awarding interest on the compensation amount minus the future prospect is due to the fact that though the loss of dependent starts from the date of the accident and the compensation amount is computed on the date of award of the tribunal, interest is awarded to compensate the loss of money value on the account of lapse of time, such as time taken for the legal proceeding and for the denial of right to utilize the money when due. However, future prospect is with regard to the probable income of the receipt in the future, and as such, there is no requirement to compensate the claimant by way of future interest or loss that is to be occur in future, as the future is yet to be happen. Further, the future prospect is given for the entire future, and as such, the claimant is getting compensation in a lump sum under future prospects prior to the occurrence of the future events. Thus, with regard to the future prospect, this court is also of the view that there cannot be any interest on future prospect, as the same relates to an income to be given in future months.
Okay.
That the first point, my lord, that regarding the multiplier, I am relying upon paragraph 42 of Sarla Verma, my lord. Excellent. Yes. Paragraph 42. Reported in 2009 6 SSC 121. Is right down as 24 minute. 42.
Yes.
We therefore hold that the multiplier to be used should be mentioned in column 4 of the table above, prepared by applying Susama Thomas, Trilok, Sand, and Charlie, which starts with an operative multiplier of 18 for the age group of 15 to 20, 21 to 25 years, reduced by 1 unit for every 5 years. That is multiplier 17 for 26 to 30 years, multiplier 16 for 31 to 35 years, multiplier 15 for 36 to 40 years, multiplier 14 for 41 to 45 years, multiplier 13 for 46 to 50 years, then reduced by 2 units for every 5 years. That is multiplier 11 for 51 to 55 years. That has been taken by the tribunal. In fact, it should have been multiplier 9 for 56 to 60 years. Apparently, that from the exhibit, he is above 55 years.
Okay.
That is the two grounds basically.
Okay. So how, without pay and recovery, how can I make the insurer pay? It's up to you. Without making the owner pay, how can I make the insurer pay?
No, they claim from the owner.
They'll
They-
recovery from the owner,
Yes.
recover it from the owner.
Yes, they can.
They can.
Yes, they can. There is a judgment of the Supreme Court.
Okay.
Now, here is only two ground here. One ground is a multiplier. Here multiplier is 11 in this
Mm.
And their claim is multiplier should be nine. This is the issue,
Mm.
because the deceased age was 55 years, 3 months.
Mm.
And in multiplier, here if for 11, 51 to 55. Their contention is that since he is more than 55, then multiplier should be 9. But here it is written in Sarala Verma, for 56 to 60, the multiplier is 9. Now I can be treated as a 56. I'm not 56. I'm 55 because 55.
At that General Clauses Act, he'll be 55 only,
55.
according to General
Yes.
Clauses Act.
So multiply is correct.
According
11.
to General Clauses Act, after your birthday, then after your birthday, you complete 1 year.
1
After
year.
your birthday, you are 1 year.
1 year.
My lord.
So,
According to General Clauses
correct.
Act.
So multiplier is correct, 11.
He
Against
was
his-
born on 1/4/1958.
If
What?
55 years, how many days?
3 months, 27 days.
3 months, 27 days. So
He was born on 1/4/1958.
this
Died
calculation.
on 28/7/2013.
So
It is 55 years, 3 months, 27 days.
So his age would be 55. If 55, then multiplier would be 11. So learned trial court rightly passed the order multiplying 11.
Why is the owner not offended, aggrieved? Owner has
Your-
not approached, why?
I don't know.
That's
He
it.
he appeared in before the tribunal,
Hmm.
but in spite of the notice, my lord, he did not appear. He opted not to appear before this court.
So second issue he has raised, my lord, that is the future prospect, that is 15% future prospect.
Yeah, Fisher prospect, I'm.
On interest,
Yes,
on interest.
only the interest part.
Only on interest.
So multiply is concerned, 11 is correct. That is my submission. Sarala Verma case,
না এইটো হয়ে গেল কোনবা
in Sarala Verma case, paragraph 42, it is discussed. Listen. No.
What she will reserve this judgment.
I can pass it also, dictate it also,
That's
but I'll reserve it at it.
my lord.
I have
That-
lot of other pending work also.
In that bin, my lord, that statutory deposit made by the insurance company, that will be,
You want to withdraw it?
yeah, that will
No,
be.
no. Already he has deposited the,
Oh, you,
Statutory deposit that.
you want to withdraw it?
no, no. You
No,
want
the statutory deposit of 25,000, that
Hmm.
to be returned to the insurance company.
insurance company.
Okay, okay.
That is
If I pass the order
My
today,
lord.
yes, yes, sure. Yes, sometimes we keep forgetting about it.
Yes, my lord.
That usually we keep forgetting
In that
about.
case, my lord, we will have to file in the IA.
Again, we have to file, usually it is done also.
No.
25,000, no?
25,000. We have already deposited 50% of the awarded amount, they have.
They have
withdrawn.
withdrawn.
They have withdrawn.
Withdrawn.
At learned counsel, Mr.
P. Hazarika.
A.
P. Hazarika.
P. Hazarika
For the
for
appeal.
the insurer, comma appellant, and learned counsel, Mr.
My lord, Mr. P.K. Roy Chaudhary's name may be there, my lord. I will assist.
Okay, okay. It is there.
My name is also there, P.K. Roy Chaudhary.
Mr. P.K. Roy Chaudhary
Yes, yes.
for respondent number 2.
1 to 4.
For respondent number 1 to 4. Reserved for judgment and order.
My lord. Oblige me.
এইটো হেৰি কৰিম। এইটো কমপ্লিটে কৰি দিওঁ। কমপ্লিট কৰি দিওঁ।
This matter was to be taken up positively today, my lord. I am for the respondent. The petitioner is absent. On earlier occasions also, they were not present. Last occasion they were present, but they sought time. It's a small matter, my lord. Matter relates to whether all the legal errors of the tenant has to be made as a party. I am covered by a judgment which supports me. And there is a stay order in their favor. It's operating since January 23. And the suit has been stayed.
So in case I dismiss it, it will be vacated then. There's a
It's
stay order.
vacated. There's a stay order operating in their favor.
I'll check.
I'm sorry, my lord, in item 13, my lord, 1 point I forgot, my lord, rejection.
Sorry?
Yes, my lord, that conventional head, my lord, the chronicity says, my lord, it should be 72. And in this case, my lord, it was awarded more than that, my
Yes,
lord, page 42, my lord. Lordship will find page 42 of this judgment, my lord.
What do you want to say?
My lord, Lordship will find page 42, my lord, of my memo of appeal, my lord. Judgment is? Page 42, my lord. That cert, the learned tribunal has.
1 to 4.
Yes.
But my lord, Lordship will find column number 5, 6, and 7. That the conventional head. Lordship will find that.
Oh, it must be reduced according to Pranay
Yes.
case. Okay.
It is much higher, my lord.
Yes.
Pranay says it is up to 70,000, my lord. Lordship will
see,
find that last point, my lord.
I don't know, at that time, Pranay case was, I think this judgment was not passed, Pranay judgment.
But yes, my lord. But that future, in that case, my lord, there is a direction of future prospect. It will be covered by the my lord, Sarala Verma, my lord. In that time, that the Pranay was not there. The Pranay judgment said 15% on future prospect up to after 50 to 60 years.
My lord,
In
Pranay
that-
Shetty judgment has clarified.
Yes.
It has not given a new direction.
No.
It has said in para 58, it has clarified the situation
Yes,
of Shalla.
My lord.
It has clarified that you cannot say a person working will not increase his salary. The moment it increases, so automatic that it will not be taken into consideration has been in the constitution bench, it has been clarified.
No, my lord, if that Pranay judgment regarding the conventional is not applicable, in that case, my lord, the future perspective will not be applicable. That is one on my ground, but I have not raised the ground at this time, my lord. Because the Sarala Verma says that after 50 years, who has a fixed salary, there will be no enhancement. But the Pranay says that after 50 to 60 years, it will be 15%. That, therefore, I have not raised the points at this now, my lord. Although we have taken the ground, my lord. In terms of Pranay, my lord, conventional will be head will be only 70,000.
Yeah, I know that.
Yes, that learned tribunal has awarded more
But
amount.
you see, Pranay judgment was not passed in that, it came after this judgment.
Judgment.
In that
2017.
event, my lord, I have done another point, my lord, point number, ground number 3, my lord, that
No,
regarding.
see, we can, according to the, all the new judgments passed,
Yes, madam.
we can, that appeal, we can consider the appeal
Yes,
according to the
right.
new judgments.
Right, madam.
There's no bar, but you see, once then amount is fixed,
My
to
lord,
reduce it according to the new judgment,
my lord.
I do not know.
That
will that
beneficial
be justified?
legislation,
If your
because these
lordship,
are all beneficial legislation. A
If your
person has
lordship-
expired
if your lordship
and he was
allows
53,
me, my lord, I will raise then the point number 3, my lord, of ground of my lord, appeal, my lord, page 8, my lord. If the Pranay judgment is not applicable to a judgment passed before that, my lord, ground number 3 also lordship will see.
No, why it is not? It is applicable.
My lord,
When you raise the amount, it is applicable, but when you deduct the amount, decrease the amount,
my lord,
then will it be applicable in a beneficial legislation?
my lord, in that case, my lord, point number 3, my lord, 15% of future prospect after 50 years. That was not there, my lord. Sarala Verma says that after 50 to 60 years, that
what
there
is the
a-
distinction between stay, quashing, what is diluting the matter, how it is, my lord, explained, whether it has overruled, whether it has distinguished, all things has to be taken into consideration by just playing that we have raised this point. Let them satisfy that it has been distinguished, it has been explained, it has been that. Those things will require some deliberation with others.
Kindly paragraph 24 of the Sarla Verma, my lord.
Let me come back after a break.
My lord.
Okay, after 5 minutes.
My lord.
Only one case, my lord. Roughly 16. 16, sure. 18, my lord. That, my lord, will not be possible for me to do today, my lord.
Okay.
And the interim order in the IA has to continue.
Okay.
Item 18.
লিখি দিব হ্যাঁ item 18 টো interim order shall remain in force লিখি দিব
In the IA, interim order in the IA has to
till
continue.
the next date of listing in the IA লিখি দিব.
Obliged.
Come back after a break,
My-
5 minutes break. Hari, 4 weeks? 4 weeks? Is it an old pending case?
No, my lord, new case.
All right. I'll come back after a break, only 5 minutes break.
The Verma judgment, it was in the year of 2009. Therefore, that at the time of rendering the judgment, that the Sarla Verma was prevailing. I am taking your lordship to ground number 3 at page 8. madam. Before that, I am reading that paragraph 24 of.
Ground number 3, page 8 of which promissory judgment?
No, my lord, that memo of appeal. madam.
Okay. Ground number?
Ground number 3, my lord.
Page 8.
Page 8, madam, memo of appeal.
Okay.
For that, the learned tribunal overlooked the decision of the apex court regarding the loss of future earning prospect. In Sarla Verma's case, it has been laid down that there should be no addition in as future prospect of income where the age of the deceased is more than 50 years. In Rajesh and Rajbir, that has been overruled, my lord. That is overruled, my lord. Apex court held that the said principle in Sarla Verma's case has been laid down in the case of salaried person having regard to the fact that in case of those self-employed or fixed wages, there is a normally no age superannuation. It will be just equitable to provide addition of 15% in the case where the victim is between the age group of 50 to 60 years of, so as to make the compensation just, equitable, fair and reasonable, and there shall be normally to no addition thereafter. In the present case, that victim was a teacher, my lord. So if we go by the decision of paragraph 24 of Sarla Verma, may I read, my lord.
Yes.
In Sushma Thamas, the court increased the income by nearly 100%. In Sarla Dixit, the income was increased by only by 50%, and in Abid Besburu, the income was increased by mere 7%. In view of the important paragraph 24, madam. Sarla Verma. Page 134 of Sarla Verma. Paragraph 24.
I do not have the judgment with me.
I have supplied 2 copies, my lord. One Sarla Verma and one Pramesati.
Rental insurance. Oh, yes, yes. Yes.
Paragraph 24, my lord. In Sushma Thamas, this court increased the income by nearly 100%. In Sarla Dixit, the income was increased by only 50%, and in Aboti Besberua, the income was increased by mere 7%. In view of the importable and uncertainties, we are in favor of adopting a rule of thumb, an addition of 50% of actual salary to the actual salary income of the deceased towards future prospect where the deceased had a permanent job and below 40 years. Where the annual income is in the taxable range, the word actual salary should be read as actual salary less tax. The addition should be only 30% if the age of the deceased was 40 to 50 years. There should be no addition. This is important, Miller. There should be no addition where the age of the deceased is more than 50 years. Now the person is if it is 55 years, Miller, in terms of Sarla Verma, and he's a teacher, Miller. It's a salary person. There should be no addition.
So according to Pranay, it will be better if I bring down according to Pranay Sethi then.
Then in that case, my lord, my lord, that
Pranay Sethi, according to Pranay Sethi, it will be 75,
my lord, 70,000 in the.
70,000. There's a fixed amount, no?
Yes,
40,000,
my lord.
70,000.
If we go by the Sarala Verma judgment, then 50% will be reduced. If we go by the prevailing, my lord, Pranay Sethi judgment, that the quantum, my lord, at paragraph page 17 of the judgment, my lord, 4, 5, 6, and 7, for consumptive loss of expression, that will be reduced, my lord, up to 70.
All right. Yes, what do you have to say?
My lord, in Pranay Sethi's judgment, my lord, para 41.
I do not have the Pranay Sethi.
My lord, I have supplied bill. Pranay Sethi also. It is clarified in point number 59.3, my lord.
Okay, para 50?
59.3.
My lord, 41, your lordship will find in Pranay Sethi.
According to you, 49, 50.
59.3, before my learned senior colleague, start my lord, 59.3, I want to read, my lord. While
Okay.
determining the income, and addition of 50% of actual salary to the income of the deceased toward future prospect, where the deceased had a permanent job and was below 40 years, should be made. The addition should be 30% if the age of the deceased was between 40 and 50 years. In case of the deceased was between the age of 50 to 60 years, the addition should be 15%, my lord. If you go by the Sarala Verma judgment, that 15% will be reduced. If you go by the, my lord, Pranay Sethi judgment, the 15% they will get. But paragraph 59.8, your lordship will also see, my lord. Reasonable figures on conventional health, namely loss of estate, loss of consortium, and funeral expenses should be 15,000, 40,000, and 15,000 respectively. In the
These are fixed.
yes, ma'am.
The aforesaid amount should be enhanced at the rate of 10% in every 3 years.
After
That is also that.
after 2017, ma'am.
My lord, what my friend is suggesting in service jurisprudence regarding in a penalty imposed in a disciplinary proceeding, regarding the second show cause notice, there was a Ramjan case. Then came the ECL. ECL overruled the Ramjan case. The ECL is prevailing. Here, Pranay Sethi has affirmed and modified that Sharla's judgment. So it is not overruled. So it has affirmed and modified. So, and it is a constitution bench. Your lordship is giving judgment in 2025. Now your lordship will say that because that court should have followed that, I will not look into in the appeal before this court, or I will just not I will not look into the constitution bench judgment. That will be not in consonance to Article 141 of the Constitution. My lord, that what it should be done is also laid down in Pranay Sethi's judgment. My lord, that is in para 28. Para 28 and para 21 and 28, my lord. My lord, para 16 to 20, if your lordship just look into para 16 to 20, that will be better, my lord. Para 16 to 20. 16 onwards, it has discussed all the judgments, and my lord, para 19, it still reads as this. Though the aforesaid was articulated in the context of the High Court, yet this court has been following the same as is revealed from the aforestated pronouncement, including that of the Constitution bench. And therefore, we entirely agree with the said view because it is a precise warranting respecting a precedent, which is the fundamental norms of judicial discipline. In this context, we fruitfully note that what has been stated in Pradeep Chandra Pujari such and such, in the said case, the Constitution bench was dealing with a situation where the two judges bench disagreeing with the three-judge bench. Decision directing the matter to be placed before the larger bench. In that scenario, the Constitution bench stated, in our view, judicial discipline and propriety demands that a bench of 2 learned judges should follow a decision of a bench of 3 learned judge. If a bench of 2 learned judges concludes that an earlier judgment and 3 learned judges in so far incorrect, then in no circumstances can be followed. The proper course for it to adopt is to refer the matter before to a bench and 3 judges bench sitting and such and such. So ultimately, my lord, here the what under Article 141 of the Constitution, the present law, because it has affirmed and modified Sharlavinda. So paragraph 58 of the Pranay Shetty's judgment, well, that will prevail over here, and your lordship deciding in 2025 can look back in the matter, has to look into this present Constitution bench judgment and decide it.
That is my precise submission. We cannot take one point from Sarala Verma and one from Pranay Shetty. If it is covered by Pranay Shetty's constitution.
My lord, we are relying in Pranay Shetty.
Yes.
Because what my friend is suggesting that 59.8, there also it has been the aforesaid amount should be enhanced at the rate of 10% every year, every 3 years.
Out that this
My lord, here it is not said from 17 when the judgment came. After the fatal accident took place, 3 years starts from that period. My lord, where from he says that it will come from in 17? He cannot say that. That will, how a person who has expired, his 10% will not increase for after every 3 years?
It is the conventional health quantum. It is not that future prospect, not that loss of income from the death or accident. It is conventional health. If it is the person died in the year 2001, and we are delivering this judgment in 2025, same amount will be there in the conventional health. That is my submission.
We are relying on this constitution bench.
I'm also relying on that constitutional judgment.
Because it has affirmed and modified. It has, that is the present scenario of the constitution bench.
You are saying after that, 3 years must be counted.
My lord, 3 years must be.
And according to you, after the delivery of judgment, 3 years must be counted.
And in any case, there cannot be an enhancement because they have not filed an appeal.
Likewise, it cannot be any deduction also.
Yes.
Likewise, there cannot be any
for deduction, but you have not prepared any appeal.
I cannot file an appeal for deduction. They have filed.
Yes, my lord.
So I am satisfied what I have got from the trial court.
I'm saying that, my lord, there cannot be an increasement above the judgment rendered by the tribunal because they have not prepared any appeal. I'm obliged.
আগতে ডিটেকশন দিয়া আছিলে ন এইটো লগাই দিলে হৈ যাব পেজ 45
Item 15, my lord. They have not come.
till now they are not
come. Because if your my lord may kindly see the order sheet reflects, my lord, they have not appeared or they have sought time, my lord. And there is stay order operating in their favor. Order sheet will reflect, my lord.
RSA?
It says CRPIO.
CRPIO. Okay. You want to submit anything?
On merits, my lord, I am covered by the judgment of the apex court, my lord. It was relied by the learned trial court also. 2018 6 SCC, page 708, my lord. Paragraph 24.
Okay.
This is and another judgment of the apex court, paragraph 38, 2023 SCC online, my lord.
That prime preliminary issue was whether the legal heirs.
Yeah, legal heirs, my lord.
What was
Le-
the case? When
My lord,
legal heirs were?
the legal heirs are substantially represented, my lord, because the petitioners herein are the legal heirs of the predecessor in interest of the defendant, my lord. They are substantially represented, my lord. And this plea was not taken in their written statement. There is no plea to that effect, my lord.
Have you mentioned in the grounds?
No, I am the respondent.
Okay, okay, you are the respondent. I'll just note it down. They have not taken this plea in the written
No,
statement.
not taken the plea in the written statement, my lord.
That the legal heirs were not included.
Yes, my lord.
Another judgment.
This is 2023 SSC online 358, paragraph 38.
Legal heirs were not represented. If I decide on merits,
Yes,
in
ma'am.
case I decide on
Yes.
merits, and if I just dismiss it, then
Then
I'll vacate the stay order.
yes, my lord.
সেই আৰু খবৰ এটা দি দিবা যদি আহে ক'ব তেওঁ পাছত এতিয়া নালাগে আৰু দুটা কেছ তেনেকুৱা কৰিছে তেওঁ এটাটো মই ফিক্স কৰি দিলো আৰু আজি এইটো এটা দুটা এইটো ক্ৰিমিনেল কেছ চিভিল কেছ হয় দুটা এইটো ক্ৰিমিনেল কেছ নহয় আগৰটো দুইটা চিভিল হয়
Then a judgment of this honorable court, my lord, that subsequent suit is not barred. Paragraph 30, my lord. Because in a ejectment suit, my lord, the cause of action will always evolve, my lord.
If I dismiss it on then
If
on default then
he can
won't
restore
suffer.
it.
He can restore it, but
He
if
can restore
on
it.
merits then
Then
he will suffer.
he will suffer.
Let's see, I'll decide, ponder over it. So according to you, they were substantially represented as who was
The legal heirs are there, my lord. The legal heirs are there in the suit.
They were substantially
Represented, my lord.
represented
And
by
that plea was not taken in the written statement.
by who?
My lord,
By
we had
family
taken
friend.
Kamla Devi Agarwal was there, then Ankit Agarwal and Munni Agarwal, they were there. The present petitioners, they are there, my lord. The three present petitioners in this revision petition, they were there. If my lord may kindly see page 12 of the revision petition, they were already there.
So he's not present.
Yes, my lord. Otherwise, it can be dismissed for default. If he comes again, he can restore it. Then on merit, he will get an opportunity. But if your order,
Proposed to do.
yes, ma'am. If my lord may kindly see the order sheet, it will reflect itself, my lord. They have not been there for hearing. The order sheet will reflect, my lord.
This plea was not taken in the written statement.
Yes, my lord.
They were the
They
respondents.
were the
there.
defendants in the suit. I am the landlord, they are the tenant.
কোনো নাহে নাহে কেতিয়াও নাহে মাতিলেও নাহে I think these people have already think bought their own property by now maybe much more better grand property than what they were staying in এইটো থৈ দিওঁ মই চাম মই ডিছমিছে কৰি দিম চাগে ফৰ ডিফল্ট তথাপিও নোট এটা কৰি থৈ দিছোঁ আৰু নাই ন 2টা বজাত